afternoon. I have a PowerPoint presentation, and throughout the PowerPoint presentation I have a bunch of political cartoons. And I have to start off by telling you that the disclaimer. The views in the political cartoons do not necessarily represent the views of the Maricopa County Superior Court or the presenter. They're here just for your entertainment. Go ahead and put it on. I'll tell you how we got started and why we're here today. And you have my court reporter to thank, and that's Cindy. We were doing a capital case in our division, and she asked a lot of questions, constantly asking questions about why we were doing certain things and why this was happening and what was this all about. And I would give her the answers, and she kept saying, I think a lot of people would be interested if you would give a short presentation. And to placate Cindy, I said, sure, go ahead. And sure enough, she came back with, they would love to have you do this. Give us a date. Well, I said, okay, well, I'm kind of busy now, but maybe in a few months. And then she kept coming and asking and asking. And so finally, to shut Cindy up, here I am. What are we going to talk about? Well, it's going to be very basic. We are going to talk about how a case becomes a capital case. We're going to talk about the different ways a capital defendant, after a death sentence is imposed, can challenge his or her conviction and sentence. And then we're going to talk about what this all means to you as the keeper of the record in a capital case. What we're not going to talk about is whether or not there should be a death penalty in Arizona. We're not going to talk about those people who are on Arizona's death row today. If you want me to come back and give you another time when we can talk about who those people are and the types of crimes they've committed, I can certainly do that. I'm having, as you've heard, I've been involved in capital litigation in my professional career for before I became a judge, almost 20 years. So I'm very familiar with what's going on as far as Arizona's capital litigation. I'm going to give you some stories that are actually, they're not stories, they're real-life events about what happens in some of the capital cases. I'm going to tell you a couple of stories where court reporters were actually put in jail to prepare their transcripts. We're going to save that to the end so none of the court reporters leave early. And I'm going to talk to you about why that happened and how we've progressed to this point. But let's start by talking about how a case becomes a capital case. Obviously, this is a jury for one of my trials. Let's start at the very basic of how a case becomes a capital case. Well, first of all, there has to be a homicide, a death. So the case starts when somebody actually dies and there's a body is discovered. Police investigate. Eventually, the state has to file first-degree murder charges. It cannot be a capital case unless the state has alleged or got an indictment or an information against somebody for first-degree murder. That would include either premeditated murder or felony murder. Then the state must file a notice of intent to seek the death penalty. And in that notice, they must allege that there is one of 14 aggravating circumstances present. And in a minute here, I'm going to go through the statute with you and show you what are the 14 different aggravating factors that the state must allege. So it's not just that there was a first-degree murder committed, but in fact, there was a first-degree murder plus at least one of 14 aggravating circumstances. Then it goes to trial. The jury must determine first that in fact the defendant was guilty of first-degree murder, either premeditated or felony murder. Once the jury makes that determination, then you have the next step, which is known as the aggravation phase. And at this aggravation phase, the jury then hears the evidence that may relate to one of those aggravating circumstances. If the jury comes back with an aggravation verdict, finding that the state has proved that aggravator beyond a reasonable doubt, then they go to the penalty phase. And it's at this penalty phase that the jury determines whether or not death is the appropriate sentence. And at the penalty phase, they will hear a lot about the defendant's life, his or her background, the circumstances that made the defendant come to that point in time in his or her life. This is really timely, especially if you're from New York. Let's look at Arizona's 14 aggravators. The first aggravator is that the defendant has a prior conviction, whether it is from Arizona or from somewhere else in the United States, where a life sentence was imposable on that prior conviction. Now, let's talk about that for just a minute before I go on. Did you know that in Arizona there was a death row inmate whose aggravating circumstance, one of his aggravating circumstances, was for a prior marijuana conviction? Because some of us I see a few of you that might be old enough to remember, back in the old days when possession of marijuana was 1 to life, well, then that means a life sentence was imposable. So that would qualify as an aggravating factor under number 1. So most of the sentencing laws around the country have changed, and we don't have those types of sentences anymore. But just to give you, it's whether or not the person's prior conviction, whether he or she, not whether they got a life sentence, but whether or not that was an option for the conviction for which they had. The second aggravator, was whether or not the defendant has a prior conviction, whether it's preparatory or completed, that means whether it was an attempt or some type of facilitation, that's what the preparatory offense is, where it was a serious offense. And the statute lists out serious offenses. And those serious offenses are such things as sexual assault, kidnapping, a prior homicide conviction. Those are the kinds of offenses that, I think molestation of a child, those are the kind of convictions that would qualify under this aggravator. The third aggravator is whether the defendant knowingly created a grave risk of death to another. You think, okay, where does that one apply? Well, it would be a situation, for example, if the defendant went into a crowded bar to kill his victim and started opening fire in a crowded bar, and it put other people at risk. That would qualify under this aggravating circumstance. Some of you may remember a few years ago where the man went into the homeowners association meeting that was tried here. That was an aggravator in that case, because he put up not only the people he directly shot at, but he put other people at risk in the area. The fourth aggravating circumstance: the defendant procured the commission of the offense by payment. So if you hire somebody to commit a first-degree murder, that would be an aggravating circumstance. And then, number 5, if you receive money for committing the crime. So if we have a murder for hire, where somebody paid somebody else, there would be an aggravator for the person who made the payment and an aggravator for the person who was paid. Also, if you commit a robbery that turns into a murder, if the motivation for the killing was to take money from the victim, that is also would qualify under the fifth aggravator, which is receipt of anything of pecuniary value. Also, if you decide you want to kill your spouse for the insurance proceed, be aware there's already an aggravator against you. All right? Keep that in mind. Number 6, the defendant committed the offense in a especially heinous, cruel, or depraved manner. I will tell you this is, I participated in a study committee that was set up by the governor on Arizona's use of their capital aggravators. It was all phases of the capital process. This was the number one aggravator that was used. So let me tell you a little bit about this, because you're going to, if you're involved in any capital cases in the system, in the court system, you're going to see this aggravator. The first part of it is when you look at cruel, that relates to the suffering of the victim. If the victim unduly suffered, and this could be either physical pain or mental anguish, then that would be this aggravator. If the defendant exhibited a heinous attitude about the crime. Okay, let me give you some examples. There's an inmate on Arizona's death row who was convicted and had this aggravator, and it was because after the murder, he and his co-defendants danced around a bonfire singing "We Are the Champions" with the bullets they'd kept from the murder in their possession, showing a truly heinous attitude towards the killing. That is what they're looking at for this particular aggravator. Another part of this would be corpse mutilation, and surprisingly there are some of those defendants who are on Arizona's death row who have had this aggravator imposed for that. Number 7, the defendant committed the offense while in the custody or on authorized or unauthorized release from custody. That would cover people who escape from either jail or prison, or if they commit a crime while they're in jail or prison. And B is just recently added, and that's if they were on probation when they committed the crime. If they were on probation while they committed the crime, that would be an aggravator. And I will tell you that was imposed in part as a way of recognizing the hard work that the probation officers do, as a way to try to say that if they hurt or harm a probation officer, that is going to be an aggravating factor. Number 8. Now, sometimes they don't have a prior conviction for a homicide, but they kill more than one person at that time. If that's the case, where at the time of the murder they've committed more than one homicide during that incident, then that's an aggravator. Number 9, the defendant was an adult and the victim was under the age of 15 or over the age of 70. It's in recognition of the vulnerability of those two segments of our society, the young and I hate to say old, because I'm getting closer, but 70 or older. Number 10, the murdered person was a police officer. It's actually a peace officer who was killed in the course of performing the officer's official duties. Number 11, The defendant committed the offense with the intent to promote or further or assist the objectives of a criminal street gang. 12. There's a lot of phraseology there, but I can give you the. If you were killed because you were a witness, or you were helping the police investigate a crime, and that was the motivation for the killing, and the notion that it is truly aggravating when somebody is trying to thwart justice to the point that they would take life they would take life as not being serious, and they would just simply kill somebody for no other purpose than to prevent them from testifying. 13, the offense was committed in a cold, calculated manner without pretense of moral or legal justification. That was put in there for the idea that because there are a few where they said we were just killing for the sake of killing. We just wanted to see what it felt like. Or people that plan out over long periods of time to kill people. And number 14, the killing, the defendant used a stun gun in the commission of his or her offense. Those are the 14 aggravators. The state must prove one of those 14 in order to be death eligible. Sometimes you will hear that phase, that aggravation phase, as being referred to as the eligibility phase, because it's truly the guilt verdict for life. The guilt verdict for whether or not he or she is guilty of first-degree murder in connection with one of those aggravators. It has to be both in order for the defendant to be eligible for the death sentence. Well, then we get to who decides whether it's going to be life or death. And in Arizona, for many, many years, the decision was made by a judge. And it wasn't until just a few years ago that the U.S. Supreme Court held, and actually this is going to be contrary to what you may have read in the papers, the U.S. Supreme Court did not hold that a jury has to decide life or death. What the U.S. Supreme Court held was that for those aggravators that I just went through with you, that with those aggravators, the jury has to make that finding. The jury would have to determine whether or not the state had proved the aggravators. So and it was in an Arizona case, and prior to that Arizona case, the U.S. Supreme Court had said it was okay for the judge to decide whether those aggravators were present. And I'm not bitter, but it was actually my case before the U.S. Supreme Court that said it was okay for the judge to make that determination. I argued that case in the early 1990s, and it's Walton versus Arizona, and I was successful. And then Governor Napolitano argued Ring versus Arizona, and she messed it all up. I'm just kidding. They reversed themselves. And they reversed that part of the case that I had argued and said, no, the jury has to make that finding for aggravation. Well, when Arizona was trying to figure out what to do with their death penalty law after that case came back, they decided, wait a minute, we don't want to go through this again. We just spent the last 20 years litigating whether or not a judge has to make a finding for aggravation. Let's give the defendant every bit of due process he or she could possibly enjoy, and that's having the jury make that final decision. Because that issue on whether or not a judge or a jury had to decide had been decided by the U.S. Supreme Court in a previous case from Florida, but just like they had decided that previous issue from Arizona, there was no guarantee that was going to be the law forever. So the legislature said, we are going to give the jury the decision on who decides life or death. And in Arizona, we call that the penalty phase. First of all, the jury has to decide what mitigation exists. Actually, the defendant has the burden to prove to the jury what mitigation exists. The jury can consider anything, and unlike a verdict where the jury has to agree, for mitigation, each individual juror gets to decide for themselves whether or not mitigation exists. It's unique to capital litigation. In every other context, we make them act as the jury act as one voice, but in this context, each juror decides for his or herself whether or not there is mitigation present. Once each juror has decided that question, then they balance what they know about the crime, what they know about the aggravators present, and they balance that against the mitigation. And in a minute, I'm going to put on the screen what the test is, so don't look in your notes. They make that balance and they make that determination. They all have to agree one way or the other. And if they don't come to a unanimous decision, then it's a hung jury, and the state may try it again. The state, under our statute, can only try the penalty phase twice. If they can't make a decision after the second time, then it's a life sentence. And this is the test. And it's right from the statute, if you were going to look it up. And it's whether or not the mitigation is sufficiently substantial to warrant leniency. So on balance, in considering all of the mitigation, and you say, okay, what is mitigation? The U.S. Supreme Court has said that mitigation is anything about the defendant's character or background. Anything about his character or background that would be the basis upon which to impose a sentence less than death. So those of you who have heard capital cases in your courts, you've heard such things as he was difficult to potty train, or he had issues with sleeping through the night. It's something about his background and character, and with some people that's as good as it gets, and that's the evidence they're going to present. Others, it's really serious mitigation, where the person had severe mental problems throughout his or her entire life and was in and out of mental health facilities. So there's a wide range of the type of mitigation you're going to hear in these capital cases. And some of it's very gut-wrenching. When you hear about children that were raised by parents that abused them from the time they were very, very small, didn't have much to eat, they developed personality disorders, and there's a shock that they would do that given their circumstances. And over a period of abuse, and their life has evolved to the point where they could commit those types of crimes that we've just talked about. One of the cases that I was involved in years ago is the young boy he was older and committed a very, very heinous crime and killed two very innocent people. But his mother sold him to a truck driver as a sex slave when he was at the age of, I think it was about 12 years old. That's the type of mitigation that can be presented. Anything about the defendant's character or background that would be the basis on which to sentence him to something less than death. The other thing is anything about the nature and circumstances of the offense. Anything about this offense, was he somewhat justified? They call that kind of like an imperfect self-defense. It wasn't really self-defense, but there's something there. Those are the kinds of factors the jurors can and should weigh in determining whether or not death is the appropriate penalty. Things that can't be considered. The cost of execution. It has nothing to do with this defendant's character or background or the nature and circumstances of the offense. We don't have jurors make a determination whether or not our law is good. That's not their decision. We don't care whether the Pope or some other foreign dignitary wishes we didn't have capital punishment. It doesn't go to this defendant's character or background. It doesn't go to the nature and circumstances of this offense. That's the decision. They can impose death, and if they vote for death, then that's what it is. The judge imposes the death sentence, and he's sent off to the Department of Corrections. If the jury says, no, we don't think death is appropriate, it's a life sentence, well, then the judge determines what type of life sentence it's going to be. It can be natural life, which means exactly what it says. He will be in prison for the rest of his or her natural life. Life with the other option, for most defendants, would be life with the possibility of release after 25 years. Again, contrary to what you're going to read in the paper, this doesn't say that the defendant is going to get out in 25 years. What this says is he has the possibility of being released after 25 years. It simply gives him the opportunity after 25 years to apply to the Board of Executive Clemency and ask for a parole, ask for executive clemency. If the board says, yes, we think you're entitled to it, then that recommendation goes to the governor, and it's the governor's call on whether or not he or she should get that clemency at that point in time. Now, there's also life with the possibility of release after 35 years, and that deals with the killing of a child. If you're dealing with killing with somebody under the age of 15, then you're not eligible for release until after 35 years. Any questions so far? Go ahead.
I do have a question.
Sure.
Regarding the possibility of release after a certain amount of years, 25, if they commit any new offense, are they put back to then continue out a life sentence, or are they retried for whatever the offense was committed while after they were released?
Okay. The question is, and I'm assuming what you're asking me is, the question is, if they're released, say they've served their 25 years and they're granted clemency, that is the end of their sentence for that offense. It's not like probation. So they're not put on probation for the rest of their life and they have to serve 25 years before they go out on the street. That's not how it works. The executive clemency that they would get would be the end of the sentence for that offense. Another question. Yes. Unlike when I was talking about the question is, does the jury's verdict for death have to be unanimous? It has to be unanimous for death and for life. And unlike when I was talking about mitigation, each juror can decide how much mitigation exists. But on the ultimate question, it has to be a unanimous verdict. Any other questions? All right. Now you understand a little bit of what it is and how we get to a death sentence. Let's talk now about the different ways that a criminal conviction can be challenged. And before I move on, I have to start by telling you, everything I'm going to go over with you now is not just for capital defendants. All of the ways I'm going to talk to you about how somebody can challenge their conviction applies to everyone. If you have too much to drink tonight for happy hour and you get pulled over, you can go through all of these steps. It's nice to know that they're all there for you, right? The issue is most people don't do that because many times they serve their time before they can use all of these steps. And all of a sudden there's less incentive to challenge your conviction if you're out. Since the government is actually trying to take somebody's life, obviously they're going to keep using these challenges for as far as they can. But there's nothing new, separate, just for them that we've created. These are the steps that every convicted defendant can avail themselves if they think they had an improper conviction or sentence. And they do. The very first case I ever argued as a lawyer was not a capital case. it was a life case where the guy got life, and the crime happened before I was born. And I argued that case in the Ninth Circuit in San Francisco because he was still challenging his conviction. So when people say, oh, these death penalty appeals go on forever, and if we just eliminated the death penalty, we wouldn't have all of these appeals, yeah, not so much. I mean, if you're in prison for the rest of your life, you have just as much incentive to appeal as the person who is on death row. So, motion for new trial. Ways to challenge your criminal conviction is a motion for new trial. You're going to see, I'm sure if you've been in a criminal assignment, you've seen these. They have to come in. I'm going to get to that in a second. There's a motion for new trial, a motion to vacate judgment. There's the direct appeal, a petition for post-conviction relief, commonly referred to as Rule 32, and there's federal habeas corpus review, and sometimes you'll hear that as 2254. And 2254 relates to the U.S. Code. That's why it's 2254. But let's talk about what each one of these means. A motion for new trial must be made within 10 days of the verdict. It's limited to very specific grounds. You can't raise just anything in a motion for new trial. You have to limit it to specific grounds. And the big one is juror misconduct. And what happens is they start, how it goes after the conviction, and they're sitting there around in the jury room talking about, and they find out that the jurors went to the crime scene without anybody knowing. Oops. They can't do that. That's jurors' misconduct. If the jurors did something inappropriate, like they flipped a coin to decide what verdict to come down with, I've seen cases like that. You laugh, but it's true. Jurors sometimes act a little on the strange side when it comes to this stuff. Not in a capital case, thank God. But just, a regular, let's just decide. Okay, he's guilty. That would be juror misconduct. That's the basis for a new trial. And it can't be expanded. They have to file that motion, and they have to raise all claims within that 10-day period. If they don't raise it in the 10-day period, they have to wait. Motion to vacate judgment, we give them a little more time to do that. It must be filed within 60 days of the judgment. That's from the date of sentence. That's when judgment is imposed and they impose the sentence. Or before the appeal is perfected, whichever comes first. For the clerk's office, a motion to vacate judgment is a separate appeal than the regular appeal. So it's filed if the defendant files a motion to vacate judgment and it's denied, the clerk's office has to issue a separate appeal on that issue in a capital case. And again, it's very limited in scope how it can be, what issues can be raised. Then you get to the big one, and that's the direct appeal. And the defendant in this case can raise any challenge he or she wants regarding their conviction and sentence as long as it's in the record. The one exception to this is they cannot raise a claim of ineffective assistance of trial counsel. They cannot raise it on the direct appeal. So they can raise anything that's in the appellate record, but they cannot raise ineffective assistance of counsel. Nor can the lawyer argue his own ineffectiveness on appeal. Now, I know that sounds funny why he would do that, but I have seen it done. And they can't do that. From the direct appeal, the defendant can then petition for cert to the U.S. Supreme Court and ask for discretionary review by the U.S. Supreme Court over what the Arizona Supreme Court did with the case. And all of these direct appeals in a capital case go directly to the Arizona Supreme Court. So the Arizona Supreme Court says no, they affirm the defendant's conviction and sentence. Then the clerk of the Arizona Supreme Court automatically issues a notice of post-conviction relief. A new attorney is appointed, and that attorney can only raise claims listed in the rule. And one of these claims that they can raise is ineffective assistance of counsel. So how that works is they appoint a new lawyer to review everything the first lawyer or first two lawyers do, because we actually can raise claims of ineffective assistance of appellate counsel. So you had a trial counsel, then you had a new lawyer that handled the appeal, then you have the third lawyer that then reviews what the first two lawyers did and raises claims of ineffective assistance of counsel. Ineffective assistance of counsel can be anything that the heir probably, maybe, could have resulted in something less than death, or maybe, probably, somehow not a conviction. So it can be anything. The lawyer didn't call the right witnesses. Well, then we have to have a hearing to hear what those witnesses would have said. And then the judge makes a determination whether the judge believes that what the first lawyer did may have affected the verdict. That's ineffective assistance of counsel. Many claims are precluded. If you raise the claim on direct appeal, then you can't raise it in Rule 32. You cannot raise that claim again. But you know what happens is you say, well, okay, I didn't raise it before because my lawyer wasn't effective. So therefore, I'm going to raise the claim. Well, so then you have to go to the substance of the claim to see whether or not the claim was valid anyway. So you see how this ineffective assistance of counsel gets you to review the whole case again. Questions on that? I'm not sure you can read this. It's the 9th District U.S. Court of Appeals, and it says, "We find the Declaration of Independence to be unconstitutional. The United States is hereby dissolved, and King George III rules." They've been known to be out there occasionally. Once the Rule 32 is over with, then the defendant can file a writ of habeas corpus in the federal courts. A writ of habeas corpus allows the federal courts to review state court actions as it relates to criminal matters to ensure that the state conviction does not violate or did not violate the defendant's federal rights. That's the issue. The federal courts, in making this determination, can only review claims that were presented to the state court. So you can't raise new claims you didn't raise over in the state court. The federal courts are precluded. They cannot consider new evidence that was not presented to the state court unless the defendant attempted to present it to the state court and the state court refused to hear it. So that's why you have a lot of Rule 32 hearings, is to make sure all of that evidence can be considered by the state courts. And the federal courts cannot announce a new rule of law in a habeas corpus proceeding because the state courts only have to follow what is the current law when they decide the case. So they cannot announce a new rule because obviously that if they were announcing a new rule, how could the state courts have followed it? So they can't announce a new rule when deciding a habeas corpus petition. Well, how does that work? Well, let's use that example, Ring example, where the U.S. Supreme Court said, oops, constitutional error to have the judge decide if those aggravators exist. That only applies to those defendants who are on direct appeal in state court, because to apply it to those defendants that had already gone past that would be announcing a new rule. And they don't announce new rules in habeas corpus decisions. Any questions on that? Go ahead.
It doesn't apply if they're post-conviction relief?
No, because our state rules say we don't apply new rules. So we've double whammied them. They don't get to apply that new, only on direct appeal. Post-conviction relief, the new rule's out. Anybody else have a question? The question was, can you apply a new rule in a PCR, in a post-conviction relief petition? And the answer to that is no, you can't. Now let's get to what you're all here about, and that's what about me? I will have to tell you, and I do have to tell you because Cindy told me I had to tell you. I get real time from Cindy. She does a great job. But I can tell when she gets tired because I get a lot of yada, 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 yada. I hope my recording devices work. I'm just kidding, Cindy. You really don't do that. Anyway, let's talk about you and what you do and why it's important. When the government is about to take somebody's life, the standards clearly have gone up. It means, unlike a regular criminal appeal where we require lawyers to designate the certain portions of the record, in a capital case, because the case is going to be reviewed forever and scrutinized, that we make everything be transcribed. We want every hearing, every time the lawyer showed up in court, every minute entry that's ever been produced. We want all of the exhibits. We want everything that's pertinent, that may be an issue later on, to be part of that record. There's no destruction schedule until the sentence is carried out. And there's actual a law that when you read it, there's some debate, but it appears that in a capital case, once the defendant has been executed, that it's a historical record, and that record means that it's never going to be destroyed. So, in a capital case, by and large, that record is going to exist forever. So let me tell you some horror stories. I didn't fare so well on my JPR from my staff. That's my staff. I figured they weren't working hard enough. Years ago when I worked at the Attorney General's office, there was a particular court reporter in Maricopa County who had transcribed, my memory is it was a day. It wasn't much, but it was about a day of a capital case. He got the death sentence, appealed. Over a year later, they were still waiting for those transcripts to be filed. The Arizona Supreme Court was sending out order to show cause after order to show cause after order to show cause. The particular court reporter did not respond. The Arizona Supreme Court ordered Maricopa County to find out where this person was. The sheriff's office tracked her down. She had moved back to New Jersey and had started a new profession and didn't want to be bothered with the transcripts. They issued an order to show cause and sent it to her address, and she signed for it, and then didn't show up at the hearing in the Arizona Supreme Court. I got a phone call. I was in charge of capital appeals back in that time period for the Attorney General's office. I got a phone call from the staff attorneys at the Arizona Supreme Court, and they told me, we want her arrested, and we want you to help. You tell us what we need to do, and we will sign it. So we prepared an arrest warrant for her. The Arizona Supreme Court signed the arrest warrant pursuant to interstate agreement. She was served the warrant and arrested. Now, on the arrest warrant, it stated that the peace officers serving the arrest warrant could release her as soon as she transcribed the transcripts. So, let me tell you how this worked. We send this off to New Jersey for them to to serve her. I get a phone call from a sheriff's office back in New Jersey. And he says, "Do you really want me to arrest this person?" And my response was, "I've been ordered by the Arizona Supreme Court. What do you think?" And he said, "Okay." Called me back a little while later and he said, "Is it okay if I don't put her in jail?" Because she had her machinery and they didn't want that in the jail cell. And they said, "Can we just have her sit here in this office? Is that okay?" I said, "Well, I don't care. She's in your custody. You keep hold of her." And I said, "But you can't release her until the transcripts are done." And he goes, "Oh, I know. She's working on them. She's just sitting here crying, but she's working on them." And then he called me, and again, my memory, I don't have it documented. My memory was right before, that was like early in the day. Right as I was getting ready to go home, he called me and he said, "She's given me the transcripts and she's signed them. Is it okay for me to release her?" And I said, "Yes." And I wasn't doing insult to injury, but I said, "And could you make sure that she tells us where she wants us to send the check for the transcripts?" And he asked her that, and then he said, "You don't want me to tell you what she said." I'm assuming it was where I could place the bill. I'm not sure. But we got the transcripts. Now, I didn't work on that case, as in, I don't know how good those transcripts were. I never heard any more about it, so I'm assuming they were okay. It seemed a little silly for one day of transcripts until you start to think about the cost to the victims and to the court system and to the lawyers that would have had to retry that case without those transcripts. That is not the only time that happened. Because it was successful that time, the Arizona Supreme Court thought, "We're going to do this again." And they did. Now, actually, this is just at 5:30 at night. Back in the early 1990s, the Arizona Supreme Court did a study committee on trying to reduce the delay on filing a record. And part of their mission was dealing with records in capital cases. I served on that commission, and I will tell you that back then the average time for a trial in a capital case was about 2 weeks. It's a lot longer now, and the transcripts are a lot more. I mean, back then we still required lawyers to designate parts of the record. We don't now. The trials are longer. I know that it takes you all a long time to prepare those, especially if you're in court every single day. You're in court every single day. The trial lasts 6 weeks, and you've got, 45 days after the death sentence comes down to file the transcripts? Good luck with that one. I know how hard it is. And I feel your pain. I know you're going to get extensions. I tell Cindy, we're going to try to work it as best we can. I know that's an issue. It's always going to be an issue. Please, 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 don't just ignore them. This is not, I don't want your picture up there. Just don't ignore them. Work with your judge. Work with the Arizona Supreme Court. I know the staff attorney over at the Arizona Supreme Court that's responsible for this. She's a very nice woman. She understands. She is going to work with you as best you can. But don't get to the point where they're issuing orders to show cause, and they're doing that to finally let somebody know who can step in. I know it's a big issue with all of the court reporters. I know that. It's a big issue in the system. For the court to say we're going to allow a year for the transcripts to be filed seems, they don't believe that's doable. And I know that's an issue between the Supreme Court and the Superior Court on having enough resources to have that done. But I know you're that person in the middle between the two competing, and I'm sorry about that. But do whatever it takes, because I do know some of those people. If you want to come and talk to me about it, I can give you numbers of people to call. But please, please, please don't be the next statistic. Any questions on that? Okay. There are repeat offenders. But I'm working with her. I'll give you another horror story, and it has nothing to do with court reporters, so I'm not beating up on just the court reporters. I was doing a capital appeal. The person was coming up on execution. He had been on death row for a long, long time. He had been tried and convicted prior to DNA. He had always maintained his innocence. And then DNA technology progressed to the point where it looked like they were actually going to be able to do some DNA testing. This isn't even with this county, so that's a bonus. It was in Pinal County, and they wanted the exhibits released so they could have DNA testing. I don't care. I don't want an innocent person to be executed when I was a lawyer. So I said, sure, we'll stipulate. I got a call from the Pinal County clerk, and I knew her, and she said, Paul, we don't have those exhibits anymore. What? She goes, well, they were stinking up the place. We figured this case had been around long enough. You didn't all need exhibits anymore. So we pitched them. Now, that's a problem. They did stink. They were bloody, fecal matter, smeared clothes from the victim. They were nasty, and I'm sure they did stink. I'm sure they weren't sealed like they are now in those nice plastic bags and whatnot. They were nasty. Don't do stuff like that. That's a problem. Those exhibits need to be maintained forever. Who knows what testing is going to come out in 10 years or 15 years? And who knows what more scientific evidence we can adduce from some of these exhibits? There was a lengthy hearing on the destruction of these exhibits, and it was determined that it didn't prejudice the defense, and he was executed. It would have been nice to know with the DNA testing that we weren't making a mistake. Any questions on any of this? Anything? We have time for questions. Go ahead. I'm sorry, I can't hear.
It's like where they have 10 days to file or the 60 days. If there's a circumstance where a hospital is doing that, does that get extended?
No. Those are jurisdictional dates, and they have to be met or it's too late. And the question is on the motion for new trial and the motion to vacate judgment, if those dates could be extended. And the answer is no. They're jurisdictional.
On the person with the transcript, just say if that person was the wrong person. Say if you made a mistake and the sheriff's made a mistake in New Jersey, would you be liable for that? Would they do something about that?
The question is, what if the person who had been arrested in New Jersey, if that had been the wrong person, that she actually hadn't done the transcripts? And would there be some liability? And I really don't think there is, because quite frankly, if you get an order to show cause and they could show that she had been served and you failed to show up, you're being arrested for your failure to show up. That's what you're being arrested for. And the only reason she could be absolved by filing the transcripts is because they didn't care that she didn't show up so much as they just wanted the transcripts. So your answer to your question is, I don't think there's any liability. If she had just gotten that notice and said, this isn't me, I didn't do those transcripts, and threw it in the trash can, bad move on her part. Because that's why she was arrested, because she violated their order to show cause. Go ahead.
Capital cases, do they always use court reporters, or do they do FTR too, or just mainly court reporters?
The question is, do we always use court reporters in capital cases, or do we sometimes use FTR JAVs? There's nothing really in the rules that mandates that everything be done by a court reporter in what I will refer to as the ministerial portion of the proceedings. So, but there still has to be a transcript provided. So we would have to, if they were, the trial, yes, I think it has to be a court reporter. But as far as, showing up on a motion to continue, I don't think there's anything inherently wrong with having JAVs or FTR do that, but not for the trial. I will say, I was an appellate lawyer for almost 20 years, and the record produced from JAVs is not good. It's not. And I don't know of any appellate lawyer that will tell you that differently. Any other questions? Were there any questions from the people on the computer? All right, well, thank you so much for attending, and go back to work.